You agree with that?
Well, I would believe that the two statements mean the same because the panel that we appeared before indicated that it is clear the challenge is directed to the nomination of Sakaja Other Johnson. So it would be whichever way, whatever other angle we look at it, it would still arrive at that position of challenging. And my understanding was that they were consolidated. That's my understanding.
So this motion is partial. They are not consolidated, but they had to go there.
They were not consolidated, they were to be had together.
And for the record, we have no objection to the matters being had, whether consolidated or separated.
Please, let's just go in another way. There's a reason I'm doing this, yeah? Because I've inherited these files and I don't know what they're about. I'm trying to get to the bottom of it. So with that clarification then, we need to look at the direction that has been issued before. I see there was direction that this matter be had together with complaint number 218. 218 of 2022. Alex Abere Musalia versus J. Sakaja and CRO Nairobi County. Okay. Is there anyone here for complaint number 218 of 2022?
Your Honor,
Mr. Kamogo?
kindly place our team on record as appearing in petition 230 for Sakaja Johnson Other.
Okay. I do not seem to have the file in court with me. But there was further direction that this matter be had together also with 217 of 2022, 226 of 2022, is Evans Kaita in court? All right. Is Timothy Ayeko in court? Oh, it is himself. Okay. Mr. Kamodo?
Yes, Your Honor.
You still appear for Sakaja Johnson Arthur in 217.
That is the position, Your Honor, with the rest of the team.
Okay. Now, 226 of 2022. Mr. Ayeko? Right. Mr. Kamodo and your team, you still continue on record on this one? Nairobi. Mr. Kipkoge, you appear in all these?
Yes, I appear
with your team?
Yes.
For the arrow?
For the time. I was going to suggest on the chair.
Yes.
that Mr. Ayeko's matter be had alone.
Yes,
Because
Your Honor.
it doesn't touch, it has nothing to do with Sakaja's issue.
Sakaja, because perhaps they are.
There's an aspect
I've
that on
nothing
his
to
own
do with
side.
Sakaja.
How did they mix you up with this matter?
No, I didn't accuse Sakaja. I only said that I accused the arrow because when I came from the Sudan, I found that the mission process had been complete.
Okay, fair enough. We'll hear this matter separately. Do you have an objection?
Even I
Mr.
have to
Kamuto?
give him the honor to this before this, to show that I was the Sudan.
I want to see your complaint form. I want to look at your complaint form. So, Mr. Yeko, you have no issue with Sakaja Johnson Atta.
Nothing really the issue on against Sakaja. I only have the issue the arrow because it is regarded innately and I'm qualified to have all the qualifications.
Correct.
And I'll seek the Sudan. I don't have any condition Sakaja, I don't have.
Mr. Kamuto, you indicated you on record for
Was biased and discriminated towards me.
Yes, we had come on record, given that the matter were, our initial understanding was that will be had jointly, but in fact the matter doesn't touch on
So we
us
agreed
at all,
to separate, yes.
so he can be discharged.
Yes. So let me mention 226, Mr. Ayeko.
Yes,
Hello? Sorry, I keep forgetting. Mr. Kipkoge, because of the proceedings in this other matter, I want to discharge the debt.
Yes.
So I'm waiting in court. Mr. Can we hear you at 11 in the morning?
in the morning.
Yes.
But you want to have a matter before this, to inform this honorable court. You know, yesterday as I was trying to serve the arrow, he assaulted me and refused to take my papers.
Don't talk to the arrow. Talk to his wakili here.
Thank you, Your
He's
Honor.
a gentleman anyway.
Thank you so much, Your Honor.
No problem.
It's regarding me because of a physical condition.
Don't engage the arrow.
Thank you, Your Honor.
Okay? Mr. Kipkoge, please receive services. There is any.
I shall accept.
Yeah. So now, that being the case, so 226 is out of the way. For there is money. That leaves us with 217, 218, and 222. So, Mr. Kamoto, in respect of 230,
Yes, Your Honor.
22,
Yes.
those are the matters that we had together with the matter.
Correct.
So I can close the file for
Sorry, you
now.
can?
Close the file for now.
Which
Now,
file?
the 2022.
You close the file?
No, those are the appearances. Isn't it?
Yes, the appearances are as we had pointed out.
Yes. And the directions were that this matter 230 of 2022 be had together with 218 and 217.
Correct.
Okay? I will call them in short. We have
247 of 2022, Elizabeth Nzilani versus Sakaja, other Johnson.
The quorum vote here for the complainant. Elizabeth Nzilani. Elizabeth Nzilani. You see, this matter was mentioned on the 12th of June 2022. The complainant was not present even then. Elizabeth Nzilani. Tuko askari hapo kwa mlango. Muita hiyo jina. Elizabeth Nzilani. Any response?
Your Honor, in the matter 247, last time I had held brief for the first respondent, now that we hadn't been served. But since it comes up again, then I ask that you press me on record to the extent that it relates to Sakaja, other Johnson. And once you signal me, I'll be seeking to have the matter dismissed.
You have questions in this one?
I would be in the matter, but the county returning officer has not been eligible. You know this will be babies.
This is the order of the committee. The matter has been severally called and there is no appearance for the complainant. I see from the record before me that on 12th of June 2022, when the complaint was called, the complainant was absent again. That said, due to the time constraints under which this committee operates under Section 74 of the Elections Act, this complaint is dismissed for want of prosecution with no other process.
Most of it.
What's the next one?
DRC number 218 of 2022, Alex Abere Musalia versus County Returning Officer, Nairobi County.
Give me 218 and 217. 218, we had called this one. Right? 217. We have 217. It's in this matter.
This is 226.
217 of 2022, Evans Kaita. Evans Kaita. Although I see from the record your appeal for the first respondent, do you continue?
Indeed, Your Honor,
Yes.
this is Elias Mutuma. The quorum is as set out before in complaint 230 of 2022. The court will note that these two matters, 218 and 217, were to be heard alongside with...
Just give me the quorum for this
Yes.
matter.
The quorum in that matter,
In this matter.
for the first respondent, I am Elias Mutuma. My learned friend, Mr. Adrian Kamodho, appears with me. My learned friend, Mr. Duncan Okach, Mr. Sigei, learned friend, Collins Kiprono, Mr. Boniface Nyamo, Mr. Kibet, and Honorable Morkomen, all appear for the first respondent. I forgot my learned friend, Mr. Omwansa Ombati, who is also appearing alongside with the rest of the team.
You see the list as well.
Yes, it is growing
Quorum
every
is not
day.
the same.
Yes.
Mr. Kipkogen?
I appear together with my colleagues, Delbert Ochola and Anthony Mwan, for the returning of Nairobi.
Please call out this file out there. Askari, ita ijina. Evans Kaita.
Your Honor, there seems to be no appearance from the complainant. The court will note that clear directions were issued with strict timelines for compliance. There has been no show from the complainant. We also confirm that we have not received any submissions from the complainant as ordered by the court. The matter comes up for hearing today. We were ready to proceed. In the absence of the complainant, we apply for this matter to be dismissed with orders as to cost for want of prosecution and non-appearance.
Any objection?
I echo the sentiment of my learned friend who would apply for dismissal of the matter. The returning officer is not seeking costs.
Okay. The complaint is dismissed for want of prosecution in order as to cost the reasons that I've recorded. There's another one. All right. Now we are left with 218 and 230. Let's start the housekeeping. I need your direction.
Your Honor, I believe 218 might suffer the same fate.
218.
Yes.
Alex
There is
Abere.
no appearance from the complainant.
Have you got it up?
Yes, you had.
Okay. Alex Abere. Okay. Mr. Mutuma.
Yes, sir.
Nani ameongea? You have to be heard. Alex Abere. Mr. Mutuma.
Yes, in the matter, Chair, should I give you the quorum?
Please do.
Yes. My name is Elias Mutuma,
Yes.
appearing alongside Mr. Adrian Kamoto, Duncan Okech, Mr. Sigei, Collins Kiprono, Boniface Nyamo, Mr. Kibet, Mr. Omwansa Ombati, and my learned friend Honorable Murkomen,
Okay.
are appearing for the first respondent in the matter.
Okay. I just want to see if I've forgotten anyone. You say you appear with Mr. Kamodo, Mr. Okach, Mr. Kiprono, Mr. Mbati, Murkomen. Is there Mr. Sigei? You're not in this one?
I have been called out.
I have.
Has he called out your name?
Yes, I did.
He didn't probably include the second name, Hillary.
And Boniface Nyamo. Boniface Nyamo.
All right. Mr. Kipkoge, you're present for the other?
For the returning officer, together with my learned colleagues,
Okay. Mr. Chola and Mr.
Anthony Mwandi.
Anthony Mongo.
Similarly, Your Honor.
Just hold on.
Yes.
No, I saw this when we had started out during pupillage. The Askari should call out just to make sure
Most of
that the complainant is not in the corridors. Askari, please call out this name. Alex Abere.
Again, Your Honor, in the matter, there seems to be no appearance from the complainant, despite clear directions. During the last appearance, we have not received any documents in form of compliance, specifically no summons, rather submissions have been supplied to us. We appeared in court ready to proceed with the hearing of the matter. In the absence of the complainant, we pray that the matter be dismissed for want of prosecution with orders as to costs.
I take it there is no objection.
No,
American.
no objection. We support the request of the matter.
The complaint is dismissed with no orders costs for reasons recorded. Okay, now. So we go back to 230. Is there any other matter? Related to this series?
Those are the matters.
Those are the others.
I don't think there's any other outstanding.
So I think then we're moving on very well. Now,
housekeeping. I want to take an inventory of what each and every party has filed. All right? In respect of the claim and in response to the claim. I'll start with Ms. Mboshe. Okay?
Yeah,
All right?
you know the chair.
Pardon me, I have to do this, yeah?
No, it is
Walk
quite in
with me.
order. I am most obliged to do that. I have tried to request my brothers here to make some space. And they are not making space.
Bwana, nyinyi wanaume.
I need to place my files somewhere.
Yes, yes. Haya. Endelea. Are you sure now?
It does not exist here.
All right. No.
If I may begin,
Please,
thank you very much, honorable members of the
please
committee.
identify the document by date
Yes,
of the document
Yes.
and when it was filed.
yes. I'll start with the complaint form, the one that is offered by the IEBC. That was filed on 9th of June 2022. It bears that stamp. That particular document has annexures.
Are they numbered?
So, because they are not numbered, but they are also referred to in a supporting affidavit, which has numbered ones. So I'll then Tanas
When is
refers.
the supporting affidavit sworn?
I'll refer to the supporting affidavit of Dennis Gaku Wahome, Gaku W, sworn on 10th of June 2022. It has a number of annexures. Annexure 1 is a copy of nomination declaration form, that is DGW1. Do I wait for the committee to confirm, or I proceed?
Just proceed, because
I don't mind
is it
waiting.
this bundle?
Yeah, yes indeed, Chair.
I
Yes.
have it, yeah?
So, go to
actually
page
paginated.
17 of that bundle, Chair. You'll find our supporting affidavit by Dennis Gaku. It is dated 10th of June 2022.
Yes.
It has annexure 1, which is a copy of the said nomination declaration form.
Ms. Motion,
Yes, Chair.
it is this volume that is then paginated from 1 to 56.
Yes, Chair.
Can
That's
agree
the
that
volume.
the chair has it.
Perfect.
Correct? What else?
Then we have a supplementary affidavit. Just put this there. That is sworn by Dennis Gaku Wahome. That is dated 12th June 2021. Sorry, 2022. I am sure Mr. Kamodo was happy with the confusion there for a minute, but it is 2022. Now, this supplementary affidavit has annexure DGW1, which is a flash disk. If honorable members of the tribunal could confirm,
DGW1 is a
it's a flash disk.
It's a letter.
Flash disk containing, yes, flash disk containing compilation of videos. I'll be seeking to share with the court. The court could confirm. We submitted 6 flash disks, black in color.
These have been served upon the other parties, or we'll get to that later. Okay. You say it's DG.
W1.
And it's an annexure, or it's referred to in the supplementary affidavit.
Yes.
What I have as GW1 is a letter. I have no record of.
Chair, is that affidavit dated 12th June 2022? Because we do have two supplementary affidavits.
This one is 15th of June.
Yeah, there are two. There is one that is dated 12th June. That one is the one that has annexure 1. I don't know if the chair can confirm.
We'll trace it. Just proceed.
All right. We have the complainant's supplementary, sorry, we have the complainant's list of authorities.
Yes. Filed on 12th?
Yes, it is filed on 12th of June 2022, the list and bundle of authorities.
Yes.
We also have another list we also have another list of authorities dated 14th June 2022. That's the complainant father list. That one is dated 14th June 2022. It's the claimant's father list.
14th June.
Yes, 14th June. List of authorities and bundle of authorities. Before that, we had filed a complainant supplementary list and bundle of authorities dated 12th June 2022. The supplementary list is and bundle is 12th June 2022.
And that is a supplementary list.
Yes. So the initial list is dated 12th.
Okay.
Then we have a supplementary list that is dated 12th.
Same day.
Yes. And then we have a further
Further
list
Dated
dated
14th.
14th.
Very well.
We have also filed a supplementary we have also filed a supplementary affidavit by Dennis Gaku, dated dated 15th of June 2022. That has annexures. Annexure 1 is a copy of our letter of request to the Commission for University Education, DGW1. Annexure 2 is a copy of letter of reply from the Commission of University Education. Annexure 3 is an annexure to the letter from the Commission, which is addressed to Honorable Sakaja Johnson. That is our supplementary affidavit dated 15th June 2022. We have also filed the complainants.
So you have two supplementary affidavits.
Yes, I'll explain why, Chair.
Yes.
One.
No, just go ahead
All
and
right.
come back to that.
All right. All right. Then we have the complainant's written submissions dated 14th June 2022.
Dated?
14th June 2022.
Were there directions that the submissions be filed in soft copy? Does anyone recall such directions? They're not.
They were not directions as such. Nevertheless, at some point in the course of proceedings,
Yes.
parties seemed, together with the committee, seemed to have agreed that we could share documents, that we could, it would be easier, especially because we had those other matters, that it could be easier for us to share documents in soft.
All right. So you have gotten to your written submissions.
Indeed,
I have them. Any other document?
that sums up our
That is it.
list.
Thank you. All right. For the first respondent.
Now, for the first respondent, we have lodged before the committee the first respondent's replying affidavit sworn by Sakaja Johnson Aga on 13th June 2022 with 4 annexures therewith. We have also filed our written submissions. Yes. Yes.
Make sure I have it. Filed it on 13th of June.
Yes, it's filed on 13th of June.
Yes. Sworn on the same date.
Yes, on the same date.
Okay. All right. I have it.
Then we have our submissions dated the 14th of June. And the authorities there too.
If I had copies.
Yes, we filed hard copies, but we can always avail the soft copies. We haven't been given that direction, but we can always avail at the request of the Honorable Committee.
But I just want to first confirm that I have received the submission. Now I have. Yes, Mr. Kamoto? That is all?
Yes, in terms of the documents filed, that will be all on our end. Yeah, though I'm slightly taken aback by the volume that has been lodged by.
We'll get to that.
All right.
We'll get to it. Just want to know what is.
Yeah, because I don't seem to have what the supplementary list and everything that has been brought to the attention of the court.
you notice there are no authorities attached to the submissions. You just have the submission. Probably as we go along, we'll just confer with the secretary and see where the authorities could have gone.
Well, Your Honor, just on the same before you move to my colleague, on the issue of the authorities, first we have a notice of appointment filed by the firm of Okach and Partners, which is dated today. Yes, this is Okach. We also have a bundle of authorities dated the 15th day of June 2022, together with a digest in respect to the same matter and in respect to the first respondent. Yes, they are filed. They were filed today. We duly served. Yeah, we had provided some copies.
Many extra copies.
Yes, yes. We can avail.
You have served your counterparts.
Yes, we did serve with it.
Chair, I have not received that. Yeah, perhaps we can.
You have many copies.
Yes, yes, we can avail. We did serve electronically, but she's my sister. I will avail one. Can actually give her mine.
I can also serve them with whatever it is they say they don't have. I have them here. I can equally give them.
On behalf of the second respondent, we have filed 2 documents. We do not have a horse in this race.
No skin in the game.
We have no skin in this. We filed a reply affidavit sworn by Gogo Albert Mbuma, the county returning officer, which is restricted to the mandate bestowed on him by law. And we have just a few moments ago filed a bundle of authorities which touches on the legal questions which we intend to address Your Honors. That's it.
I have your affidavit. Oh, okay.
Yes, I've served. But for the record, I have not been served with all those documents. They made reference to accept the copy.
You have no skin in the game.
Yes, I don't.
You don't. Well, I'll direct the person.
It is important. Maybe there is something in there.
Okay, that is the extent of the documents that have been filed in this matter. I believe council now are settled that is what is
Not quite so, Your Honor. We have an issue to raise in respect of the documents filed by the court. Yes. Yes.
Let's go in another way.
Much obliged.
Right? Now, that is what each party has filed. As to whether what each party has filed is on record, that is something now we are going into. Okay? Now, have all these documents been exchanged so that each party has a set of what has been referred to by counsel for the respective parties? Ms. Mboshe,
Indeed, Chair.
you have all the documents from the respondents.
I have, including the one that I've just received, yes. And I confirm that I've also served them. And I'm happy to share anything that they may not have.
Okay, while you're on your feet,
Yes, Chair.
please serve Mr. Kipkoge
Most certainly.
the documents you have not signed. For the respondents,
Yes, Your Honor, our documents are being served.
do you have all the documents from Ms. Moshe?
Well, I'll give her the benefit of doubt because she's still distributing.
Will I give you guys a few moments?
I confirm I have served my brother with all of them. I just want to serve counsel for the IEBC.
Sorry, I don't have enough water to go around. Sorry. Forgive me.
I confirm that everyone has everything.
Kila mtu ameridhika sasa. Okay? Sasa. Let us now proceed. Right, now, I'll go back to the directions. So those were the directions that were ordered by my colleague, which I believe each and every party has then satisfied. So as we sit, are we now ready to hear the complaint?
Well, as you mentioned, those partly were the directions that were given.
Yes.
Because we were to exchange the responses, the submissions, and come for hearing today.
Yes.
However, there are some directions that have not been issued,
Okay.
meaning that parties could not have acted in that regard. One of those directions is the filing of supplementary affidavits. So there were no directions were given, nor was there leave that was sought to file any supplementary affidavit, and therefore it would not be procedurally in order to have any of them on the record, and I would therefore be requesting my colleague Mr. Mutuma to make a formal application on the same.
Thank you, Chair. The court will note from the record that clear directions have been issued in terms of how to dispose of this matter. Strict deadlines were given. In fact, the last document ought to have been filed, I believe, on or before yesterday, the 13th day of June. We complied on our part, including filing of submissions. To our surprise, the complainant has gone ahead and introduced two documents titled supplementary affidavits, one dated 15th of June 2022 and the other one dated 12th of June 2022. Now it goes without saying, Your Honor, that when a party approaches court they have put in place all the documents in such a manner that a respondent invited to defend the matter will know exactly what they are facing and to be able to prepare their defense. That is part and parcel of a right to fair hearing. What we are witnessing today is trial by ambush, where a party seeks to reinvent their case disguised as a supplementary affidavit. We have had a cursory look at the two affidavits. They introduce a new course of action not previously captured in the complaint. So we will be disadvantaged because we will be responding to a new claim without the benefit of putting anything on record. Now, my learned friend and sister has not even bothered to seek leave when she was telling court the kind of documents she has filed. She presumes that those documents are filed regularly and they are on record properly. Had she sought leave, we would be talking about that application for leave. As we speak, those documents are irregular and they have been filed without leave of court. As far as we are concerned, Your Honor, they do not exist on record. It would actually be too generous to even apply for them to be expunged from record or even struck out because they do not exist in the eyes of the law. So we ask the court to disregard those two specific affidavits and allow the matter to proceed without the two affidavits. That is our request and prayer, Mr. Chair.
These affidavits dated.
I am guided that we need to have them expunged from record. Not strike out because they are not even on record. Let them be expunged from record.
When are the two affidavits dated, Mr. Mukulu?
One of them is dated 15th of June 2022. The other one is dated 12th of June 2022. The court will note that 15th is today. In fact, we were served with this affidavit on our way to court.
You're finished, Mr. Mukulu?
Yes, I have.
Motion.
Indeed, thank you very much, Chair. To say that we strongly, vehemently oppose that particular application by counsel for the first respondent on 4 grounds. One, Chair, when we appeared before the other panel of your brothers, and also it is straight law that the complainant has a right to respond once a replying affidavit has been filed. There was leave to the complainant to reply to the affidavits that were filed by the respondents. The affidavit, the supplementary affidavit dated 12 June 2022 is in response to the replying affidavit by the second respondent. And by that time, honorable members of the tribunal, of the committee, the first respondent's counsel had not come on record. When we appeared before your brother's tribunal and my brother Mr. Kamodo came on record for the first respondent, they were then allowed to file their reply, which they did, and their reply is dated 14th. The reply is dated 14th, which is yesterday. Is it either 14th or 13th? It is either dated 14th or 13. I need to make that clarification so I do not mislead this committee. And therefore, our supplementary affidavit, this one dated 15th June, is in response to the reply by the first Respondents' Council. And it states that even the first supplementary affidavit states exactly that. It refers to the contents of the first respondent, of the second respondent, and the first and second respondents respectively. So the fact that we filed those affidavits was because we had been allowed to file our response if need be, and we found the need to file. The question of the fact that we have filed them today, that it is dated 15th and not perhaps 14th, I will respond on the three other limbs because I had said I have four. The first limb is that as we sit here and as I stand, Chair, honorable members of the tribunal, it is extremely dishonest for the Respondents' Council to act as if they are first interacting with those documents that are annexed, because that document they are seeking to expand has two annexes that are extremely critical to this matter before this honorable court. It is the letter that we have written to the Commission of University Education and their reply, which confirms the revocation of whatever it is that the complainant are alleging to have. So because that is actually what they're seeking to do, Chair. And it is dishonest because they themselves have gone ahead and filed a JR application number E87 of 2022, which is the subject that the contents of that letter are the subject of JR which they have filed after we have filed or whichever. Therefore, they would suffer no prejudice.
Go slowly, Ms. Moshe.
Yes.
Because, what I'm hearing is that what is sought to be introduced by way of this affidavit,
yes,
lies before the High Court.
According to, it is they who have rushed now to the High Court. I have just learned myself, Chair. As I was here,
JR number?
E87 of 2022. And
on the subject matter of your supplementary affidavit?
Yes.
Dated?
The supplementary affidavit? 15th June 2022. And those contents of that affidavit, Chair.
Yeah, I've seen what it seeks to introduce.
Yes, it is in response to something they have said. We did not have that information. We had written to the commission seeking that information.
They have subdued those proceedings?
No.
Are those proceedings filed? Mr. Kamoto?
Indeed, yes, I can confirm
When are they
that
filed?
today
You have a copy of those pleadings?
I have them in soft copy, Your Honor. I can supply the copy the same, but they're only limited to the issue, and their client is not a party. We are only suing the Commission for University Education, challenging the revocation of the recognition of the respondent's degree.
Thank you.
Yes.
Ms.
So that's a quite different
Ms. Moshe,
issue.
proceed.
Yes, Chair.
So you say that the subject matter of your supplementary affidavit dated the 15th of June 2022 has been has been brought to the attention of the High Court?
It has not yet. What they have done, Chair, and that is the dishonesty here I'm talking about, they have taken the document to try and sabotage the proceedings before this honorable tribunal, because that is the subject matter.
Your Honor, I'll be forced to object to that line of argument.
Look,
That we
And
intend on sabotaging this
I
proceedings.
do not intend
Yes,
to invite discourse on this issue.
yes,
I just wanted clarity on whether there is indeed a matter that has been filed with the High Court
yes,
on what is then
yes,
the subject matter of the
yes,
supplementary affidavit
yes,
dated 15th of June
Yes.
2022.
May I clarify that?
If
Yes.
indeed that is the case,
Yes,
yeah,
yes,
I would direct you with the concurrence of Ms. Mboshe, okay, that you avail a soft copy of the filed proceeding.
we can do that
The committee
immediately.
would want to see what is before the High
We
Court.
can do that immediately if
There will be a
I can
series
share
of
through the
copies.
email. Yes.
Chair, can I raise an issue?
Yes.
I think that's difficult because of 2 or 3 reasons. The first is that the jurisdiction of this committee is limited to the decisions of the county return. No, it's important.
Mr. Mbati.
No, let me make. I'm entitled to make my point.
Yes, but in an orderly way and with leave of this chair.
That is why I've requested.
Yes, and Mr. Mutuma is here. You see, you are in the same team. Isn't
Yes.
it? There is a way I want to go about the business of this matter. All right? Kindly allow me to do so. All right? Okay? If we are not going to agree then to cooperate with the panel, we are going to live here until kingdom comes. All right?
Yes.
So, Ms. Moshe,
Yes, Chair.
listening to you, it appears the other proceedings running parallel to ours.
Not at all, Chair. I'd like to say something.
Mhm.
Just because there is dishonesty, as you can see, Chair. And I'll say this. The fact that they have that letter and they have already rushed with it elsewhere, even though these proceedings are going on, means that they are not interacting with it for the first time. They will suffer no prejudice if this matter, if those documents are before this honorable tribunal. They suffer no prejudice. In fact, perhaps when they're still here, they can confirm, because they can confirm that they have no stake on that matter. Therefore,
There's no problem.
and
I want to see what is filed before the
Chair, on my final point, if I may, the question of leave. I think Chair has seen that the document by Mr. Kimodo was served upon us on 13th, his replying affidavit. We had written to the Council of University Education. They had not yet furnished us with a reply. When we received the reply, which we have attached, we immediately responded.
Okay.
There has been no undue delay. We have been before this honorable court. We have been here the whole day, waiting.
Okay. Ms. Mboshi, just one question.
Yes.
And this is for purpose of assisting the committee. Was there leave to file supplementary affidavit?
Leave to file any responses. That is our response. We called it the supplementary affidavit. That is our response. And Chair,
That will not be the
And
position, Your
Chair,
Honor,
even
on the
the
record.
rules-
Let the record speak for itself.
and even the rules of
I'm
natural
looking at the
justice.
record.
Yes,
I'm looking at the record.
most obliged.
You know, we are dealing with
It is true.
election timelines.
Yes,
And you know what then it means.
most obliged,
That is
Chair.
why you see my inquiry has been rather deep
Most
than any other civil matter that would ordinarily appear before bench. Okay?
Are you able to access your emails if we send it to you? Give us your email.
Okay.
In fact, it was said that we could file the replies and our submissions.
I'll read from the record.
Yes,
that I have.
indeed.
Okay.
All right.
I believe this was on the 12th. The quorum was Mr. Nimodi, Mboshe, Cherono for the complainant, Kamodo for the first respondent, Gogo was present. Mr. Nyamodi, we have not been served with the replying affidavit filed by the first respondent. There might be further matters on the same position. Okay, Gogo have not received the replying affidavit in this matter. Kamodo, the replying affidavit has not been filed. 6 a few minutes to regularize the file. We will be seeking recusal of a member of this panel. I guess that is why you are all here. I have seen 3 complaints. I agree that the matters be heard together by 12 noon tomorrow. Okay? I seek to raise a preliminary issue on the composition of the bench and seek the recusal of one member as the respondent has relations with one of the candidates. There were then directions. This matter to be heard together with complaint number 218 of 2022, Alex Abere, number 217 of 2022, and number 226 of 2022. The respondents to file and serve responses in all the files by 12 noon tomorrow. I guess that is the 13th. The complainant to serve the respondents with submissions, lists, and a bundle of authority by close of business 14th of June 2022. The parties to file and exchange their written submissions by close of business on the 14th of June 2022, not more than 8 pages, spacing 1.5, font 12. Any intended application for recusal to be filed and served by 12 noon on 13th of June 2022, I believe that has been overtaken by events. Matter to be mentioned on 13th of June 2022, mention on the application for recusal at 2 p.m. on 13th of June 2022. Substantive complaints on all files be heard on 15th of June 2022 at 2 p.m. Number 8, registry to facilitate the furnishing of the complainants to all of the complaints to all the parties and the parties' costs. Orders to apply in 217, 218, and 226 that we have dealt with and had the matters discussed. The next page is fairly plain, and I'll show it to you. So there was no leave to file the affidavits we're discussing today.
Nevertheless, the chair.
Okay.
Well, I have had the chair read out. I see that there may indeed have been an omission. Nevertheless, Chair, it is strike law that the complainant has a right to respond. And I believe Chair has been exercising that even as we have been hearing this, even as we have been before this tribunal today, that the complainant states its case, a response is given, and a rebuttal if necessary. It is strike law, Chair, honorable committee members. The other limbs of why I'm urging that the documents be admitted and that, opposing to the application by my brother is on the ground that this affidavit is critical to the determination of this matter. Chair, honorable members, unless we are saying that we are engaging in a casual exercise, but my understanding, and which is my humble submission, is that we are seeking to get to the bottom of the issue before us, and that therefore that particular document, even under Article 159 of the Constitution, honorable members of the committee, because of its necessity to determine the matter, the application by the first respondent should not be allowed. And indeed, Chair, if they were genuine about that particular objection, nothing would have been easier. We served them, we filed and immediately served them. What they did is that even they went, filed, whatever they have filed, and they had not even bothered to bring it to the attention of this court. They are trying to steal a match here. They're trying to steal a match. They do not want to get to the bottom of it. Article 159 does not allow that, and neither does statute. Honorable members of the committee, the respondents will suffer no prejudice if the document is before this court. If, as they say, if it is true what they are saying, that they will supply those documents and they have agreed that the subject matter is indeed with respect to that particular certification, and that is why the council is a respondent, then they will have their day before the High Court in that particular matter. They suffer no prejudice in this case. That is our humble submission. We therefore humbly seek that this committee sees through the dishonesty of the first respondent, sees through the need, the critical need to allow to have that particular affidavit on record, as it is extremely critical. They will suffer no prejudice, and the complainant had a right to respond. That is all.
Mr. Kukovi.
Honorable Chair, we have no comment on the request made by either party.
In a brief rejoinder, Chair, with your permission, brief as possible, we have been accused of being dishonest. We have been accused of trying to steal a match. We have been accused of trying to sabotage these proceedings. I wish it to go on record that that is untrue. I will start with the issue of the JR matter. I do confirm that this afternoon we have filed a judicial review matter in the Judicial Review Division of the High Court. That matter is 87 of 2022. The single issue in that JR matter, which we have now shared through the registry email, so it can be accessed by your assistants, is the process arrived at by the Commission for University Education this morning, purporting to revoke the recognition of our client's degree. It has nothing to do with the proceedings herein. We are not in any way seeking to have these proceedings stayed or reviewed by the High Court. Commission for University Education is not a party in these proceedings. It is the principal party in the JR matter. Now, it goes without saying that this committee has no jurisdiction to challenge or to revoke or to review the decision by CUE. It is only the High Court that can do that. So we moved to the right jurisdiction, and we will get justice when we appear there. It has been confirmed, Honorable Chair, that indeed the record does not support any application for leave to file a supplementary affidavit. Even as we speak, counsel for the complainant has not sought leave to even have her affidavits deemed as properly filed. She ought to have made that application. She has not done that. That being the case, the only just thing for the tribunal to do is to expunge those 2 affidavits from record. They were filed without leave. No leave has been sought so far. What counsel is seeking to do is to justify what is unprocedural. She has gone a length to explain that they have a right, but where does that right lie? How is that right comparable to the right of the respondent, who is faced with 2 affidavits, voluminous, introducing absolutely new facts that he has no chance to respond to, having filed his submissions? We are only here to highlight submissions. I will allow my learned friend to just highlight one authority in support of our submissions. Then we can rest our case.
Chair, this is a reply. They cannot highlight submissions on that. And even as I object to that, Chair, I'll also say that what he has just done is exercising exactly that right of reply that they are saying we did not have.
With the leave.
We sought leave of the court.
Yes, but my lord, if you allow me, because this is a matter that has been settled in law, so we don't need even to belabor. Leave must be sought, and I cite an authority in petition, High Court petition number 47 of 2020.
Chair, on a response.
These are matters of law.
On a
matters
response,
of
Chair.
law can be raised at any point. You are aware.
No, Chair. He's out
I
of...
didn't interrupt when you are talking. Let's respect the court, kindly.
Chair, we seek your direction on that issue.
Mr. Kamoto?
Yes.
Let's not excite the proceedings more than the...
Yes.
Already.
Yes, that's why I'm doing that. I'm relying purely on an authority, and that's what I'm producing. Petition number 47 of 2020, that is between Miguna versus Lufthansa Group and others. The circumstances were similar to what is here, because the thinking was that leave is automatic when you are responding. But this is what the court said at paragraph 11. At paragraph 11 of that decision, the court said the petitioner applicant filed a further affidavit without leave of the court. Even when the applicant came for mention to confirm compliance, the advocate for the petitioner never sought the leave to have the further affidavit admitted into the record. That being the position, I decline to admit the further affidavit and I expurge it from the record. So, affidavits filed without leave have only one medication: to be expurged from the record.
Chair, now that you have given them the right to cite the law, I hope you will allow me to do the same. Thank you very much, Chair. First, to start by saying that this is a tribunal, and even from the proceedings, and I believe it's the same thing that perhaps has been happening here, when we were in the, before the other bench, they did indicate that as a tribunal, it is not bound by the strict laws of evidence and procedure. That their idea of this tribunal is to get to the bottom of the inquiry. Therefore, any necessary information for purposes of determining an inquiry becomes critical before this tribunal. That is what was indicated in terms of the question of procedure and evidence. Again, honorable members of the tribunal, under Article 50 the right to a fair hearing, honorable members, and that particular right includes the right to be able to respond. No law is above the Constitution of Kenya. So whatever law that my learned brother is citing, it cannot certainly go above the provisions of Article 50 of the Constitution. It is indeed a humble submission that it is on that particular basis that Article 159 therefore is there with respect to the questions of technicalities. We rest.
In 30 seconds, Your Honor, just 30 seconds, or one issue, I beg. 30 seconds, Your Honor. Most of the life.
Very briefly, this is the ruling. The committee, the first respondent through Council Mr. Mutuma and Mr. Kamodo, the respondents have made an application to have the supplementary affidavits of Dennis Gaku Wahome dated the 12th and the 15th of June 2022 expunged from the record for being filed without leave of the Honorable Tribunal. The complainant, Ms. Mboshe, urges that the same be allowed on record, although she does not make an express application for leave to have the affidavits on record for that purpose. The committee has inspected the record of the tribunal, and it notes that indeed no leave to file supplementary affidavits was granted by the committee on the 12th of June 2022. We all know the subject matter of the complaint, and what brings the complaint before the committee is a question as to qualification for the nomination of the first respondent by the returning officer in Nairobi County. When confronted with a similar scenario. The Supreme Court in petition 3, 4, and 5, that is Raila Odinga and 5 others, at page 7 of its decision, that is the ruling dated the 26th, sorry, I will get the date, stated that parties have a duty to ensure that they comply with respective timelines and must adhere, and the court must adhere to its own. There must be a level and fair playing field so that no party or the court loses the time that he, she, or it is entitled, and no extra burden should be imposed on any party or the court as a result of omissions, inadvertence, or advertence which were foreseeable or could have been avoided. Again, the committee notes from the record that on 12th of June 2022, no leave was granted to file supplementary affidavits, and the matter was set for highlighting of submissions today. There has not been sufficient reason shown as to why this committee should allow the supplementary affidavits dated the 12th and the 15th of June 2022 on the record, especially noting that what the committee is to inquire is about is about any wrongdoing of the returning officer on the date of the material nomination in this matter. The subject matter of the affidavit dated 15th of June 2022 seeks to introduce letters of the Commission for University Education dated the 14th of June 2022 and another one of similar date. The nomination of the first respondent was done on the 7th of June 2022 when the subject material was not before or could not have been before the returning officer. The committee also notes that the subject matter of the two letters cited above is before the High Court in Judicial Review number 87 of 22. And although no stay has been shown to exist against the utility of the subject letters, the committee is rested on the fact that the issue is now sub judice before a superior court. Article 159 and 50 of the Constitution cannot be called upon as a panacea to breach of procedural timelines, especially in matters election, where adherence thereto is exceptionally strict. And again, I borrow from the jurisprudence of the Supreme Court on this point. Noting that no leave was granted to file the supplementary affidavits dated the 12th of June 2022 and 15th of June 2022, and noting that this matter was slated for hearing today and all parties present are ready to proceed, noting the subject matters of the letters in the affidavit dated 15th of June 2022 were incontestably before the High Court in the matter just cited, that is E87 of 2022, hence sub judice, and address events post the registration of the first respondent by the second respondent, and hence inapplicable for purposes of the events of the 7th of June 2022. That being said, it is the order of this committee that the affidavits dated 12th and 15th of June 2022 be and are hereby expunged from the record of the committee. Please,
Don't bring
this is a court. We must observe decorum. Okay? You wengine tuache. Sasa. Now, I know this matter lies before this committee for highlighting of submissions. Are we ready to proceed?
Yes. Chair, I would need to take instructions given the finding that has just been made, because the affidavit dated 12, for instance, had never been objected to. So we had also prepared with respect to that. But I would need to take the directions if we can be given, say, 10 minutes so that I can confer with my client to take instructions on that. but also based on the orders that have been made, on those ones I would like to seek leave to appeal those particular orders. Yes. So if I hear somebody saying no leave is required, but we have just had something here going on, anyway, so I would seek leave, Chair, on that. And then number 2, I would seek about 10 minutes so that I'm able to take instructions, because indeed I was willing to proceed, and on the basis of all my documents that were on record and which I did take the court through. Yes. So I'll just need 10 minutes to get clarity on that. Yes.
Yes, Honorable Chair, thank you for that decision. It's quite wise and we appreciate. We do not, we want to indulge our sister for the 10 minutes subject to the tribunal granting that. Yes, and for the record, we are ready to proceed on our side if we have to proceed now or after the 10 minutes.
Mr. Kipkuge.
We have no objection to the request by my learned friend for time off to take instructions. We are also ready to proceed this evening.
Now, 8:10. We can convene at 8:30.
We are also obliged. Much obliged.